Hey, good morning, everyone. My name is Sarah Mangelsdorf. I'm a partner at Fox Smith, and my partner Stas and I are going to be presenting to you today on issues of COVID-19 and just some considerations for that for employers. And really the focus of my presentation is going to be some recent litigation trends in light of COVID-19. And before I get into some of those specifics, I kind of want to take a step back and just really talk about some recent trends with these types of litigation and where it's going and really why it should matter to you. So, for example, last June through August, employees filed approximately 440 lawsuits with respect to COVID-19 in the workplace, and this summer that number has increased to over 700 in that same period of time. Additionally, in the last 8 months of 2020, there was an average of about 160 cases filed a month relating to COVID-19. And in the first 8 months of 2021, there's been approximately 250 cases that are filed each month relating to COVID-19. In addition, there's obviously a bunch of different hotspots where these lawsuits have been filed: California, Texas, New York, but also Illinois is another hotspot where we've seen a lot of cases filed relating to COVID-19. In addition, it seems like healthcare workers seem to be more of a target for employers who are seeing these types of lawsuits. In particular, about 1 in 5 of the cases filed relating to COVID-19 are against healthcare employers. Additionally, a majority of the cases that we are seeing are discrimination, retaliation, remote work, and leave cases. However, there are some additional cases relating to wage and hour, unsafe workplace, wrongful discharge, and negligence. In addition, it seems like smaller employers are also bearing the brunt of litigation. For example, employers with 50 or fewer employees comprise about 30% of the lawsuits that have been filed. Companies between 51 and 100, it's about 10%, and for companies with under 500 employees, about 60% of all COVID-related litigation is filed against those types of companies. So really, I'm going to talk to you about kind of 3 areas where we're seeing the most litigation, and we'll do a presentation on each of these alone, but I'm going to try and give you kind of a high-level view. So first, I'll go through and kind of tell you what it is that the law requires with respect to these types of claims, and then just kind of provide you with maybe some practical advice to help you kind of navigate through that in your everyday work environment. So first, these types of lawsuits are discrimination, and really a lot of those are failure to provide a reasonable accommodation. And I know Richard talked about that a little bit in his presentation. And so what does the law require? Well, the ADA defines a person with a disability as a person who has a physical, mental impairment that substantially limits one or more major life activities. So for example, there's a case currently pending in the Southern District of Ohio. It's called Hatfield versus ELC Beauty. And just to kind of give you an example of the flavor of cases that are being filed, this is a retail employee who alleged that her former employer violated the law as a result of a face mask policy and requirement. And their face mask requirement was for their employees and not for customers of their stores. So after this particular employee was wearing her face mask, she found that she was having trouble breathing, and it would cause her to have bouts of congestion and coughing. And so she went to her doctor, and her doctor diagnosed her with an unidentified condition, that would make it difficult for her to wear her face mask. And so the doctor recommended that she go back to her employer and see if there was an alternative that she could have to wearing a face mask. So when she returned to work, she suggested to her employer that either she not wear a face mask or that she wear a face shield instead of a face mask. Well, the employer denied her request and didn't offer her an alternative. And then as a result, a lawsuit was filed after she was terminated. Okay, so in the event that an employee is a qualified individual with a disability, the employee and the employer should sit down and kind of engage in an interactive process in order to determine whether or not there's a reasonable accommodation that exists. So what do we mean by a reasonable accommodation? Well, reasonable accommodation is any change to the application or hiring process, to the job, to the way the job is done, or the work environment that allows a person with a disability who is qualified for the job to perform the essential functions of that job and enjoy equal employment opportunities. However, even though you're required to have a reasonable accommodation, employers need to know that this obligation is not unlimited and that an employee is not necessarily entitled to an accommodation of their preference. So if you read on in this slide, it says accommodations are considered reasonable if they do not create an undue hardship or a direct threat. So what do we mean by undue hardship? So an undue hardship is created by an accommodation that is more than de minimis. And it's more than a de minimis cost or burden on the employer. I'm going to now focus a little bit more on kind of the direct threat. The EEOC has defined a direct threat as a significant risk of substantial harm that cannot be eliminated or reduced by a reasonable accommodation. In fact, the EEOC has concluded that COVID-19 constitutes a direct threat to individuals in the workplace. Therefore, accommodations that may facilitate the spread of COVID-19 may not constitute a reasonable accommodation and may not be required under the law. So federal regulations have identified 4 factors that encompass a direct threat of for an analysis, and these are the duration of the risk, the nature and severity of the potential harm, the likelihood of the potential harm that will occur, and the imminence of the potential harm. Okay, so what does this mean for you as the employer? Well, it's important for employers to utilize a fact-specific approach in each situation. And so really, I've kind of outlined a series of questions that you should kind of go through and ask yourself. And the first is, are you on notice that the employee may have a disability? So notice doesn't need to be specific for the employer, but rather whether you have reason to know that the employee is experiencing a condition that substantially limits a major life activity. So next, you need to look at what are the employee's essential job functions. So you should determine the core primary duties and requirements that encompass an individual's job. So this assessment shouldn't just be what's actually in the employer's job description, but you really need to look at kind of what an employer does on a day-to-day basis. Also, you need to be asking what a reasonable accommodation allow the employer to perform the essential functions of his or her position. So kind of going back to that example in Hatfield, with the use of a face shield or other PPE instead of a more traditional face mask have allowed the employee to perform the core duties of their position. So if so, then that may be a reasonable accommodation under those circumstances. Next, you should ask, have you engaged in an interactive process with the employee? And I know Maggie had talked about this in her presentation, but this really is very important. You always need to constantly be engaging with your employees to really have meaningful input to see whether or not there is a reasonable accommodation that exists. Then finally, you should ask yourself, would the proposed reasonable accommodation constitute a direct threat to the employee or to others? So again, going back to that Hatfield example, the employee alleged that one possibility offered by her included working without a mask. Well, if she's in an environment where she is constantly around other employees and in close proximity inside, not wearing a mask is probably not a reasonable accommodation. However, if she's by herself in an office, there might be circumstances where if she's alone and not around anybody else, not having a mask on could be a reasonable accommodation in certain circumstances. Okay, next I'm going to focus on retaliation and whistleblower claims. And for those of you who have attended our presentations in previous years, have probably seen a presentation that I did on this. So I'm not going to go into the specific of detail, but if anybody has any questions, certainly come up to me after the presentation or feel free to email me if you would like more information. But essentially, under the whistleblower claims, OSHA enforces more than 20 whistleblower statutes protecting employees who report violations of various workplace and workplace safety and health violations. So what does the law require? Well, these statutes prohibit an employer from discharging or taking an adverse action against an employee or engaging in certain protected activities. So what does that mean? Well, an employer can file a lawsuit. Well, who is an employer? An employer is just not someone who works for you. It can also be an applicant for an employment, a former employee, or an employee's agent or representative. And when I'm talking about a protected activity, what is it that I mean? Well, they generally fall into 4 different categories. It's providing information to a government agency, filing a complaint or instituting a lawsuit or some sort of a proceeding, testifying in a proceeding, or refusing to perform an assigned but unsafe task. So once there's an employer with a protected activity, what is it that they have to prove in order to bring a retaliation or a whistleblower claim? Well, they need to show that an employer knew or suspected that the employee engaged in a protected activity. So this doesn't have to be a statement. It could be the timing of the action. It could be the behavior of the employer, or a deviation from their normal practices. And also, an employee must show that the protected activity motivated or contributed to the adverse action. So what do I mean by that? Well, a contributing factor is any factor which alone or in connection or in combination with another factor affected the outcome of the decision. On the other hand, a motivating factor is that it was a substantial factor in causing the adverse action. And then finally, an employee must prove that they suffered an adverse action. Well, what do I mean by that? It could be discharge, it could be demotion, it could be constructive discharge, it could be reprimand, harassment, just kind of a variety of actions that an employer takes. So for employers, what can you do to kind of help protect yourself against these types of lawsuits? Well, you need to have a strong compliance program. I know that our previous panel had talked a lot about that, but you really need to be proactive and have a strong program in place that addresses these policies and procedures. Also, it's important to have multiple channels for employees to be able to come to you if they have any questions or concerns that they have. So you can have an open door policy, you can have a form that they fill out, an email, you can have your supervisors walk around, kind of ask questions, make sure everybody's okay. But the more avenues that an employee has to talk to you, the employers, and come to you with their concerns, the better off that you'll be and the better able you'll be to address them. In addition, you need to provide training. As Maggie mentioned, you can have the best policy in the world, but if nobody knows about it and if nobody's trained on it, it's not a good policy. You need to constantly be training not only the employees on these policies, but you also need to train your management on how they need to implement these policies as well.
Sarah, I think there's a question.
Yes.
From the chat, how are public entity employers who aren't under OSHA jurisdiction affected by the federal COVID vaccination mandate?
That's an excellent question. And actually, if you can hold off on that for just a minute, because Stas is going to be talking in depth about the vaccination mandates.
Excellent, thank you.
Okay, all right. In addition, as Tom had mentioned, once you do have your policies, you need to be consistent with these policies. So you can't treat one person differently in one circumstance and then treat somebody differently under similar circumstances, because inevitably you're going to have finger pointing that you treated somebody differently in this way, and then you're subjecting yourself to potential lawsuits. Okay, finally, I'm going to touch on some remote work and leave considerations. So as of the mid-2020s, the number of full-time remote workers has increased by 40%. And there's a recent poll that found nearly 2/3 of the people who are working remotely would like to continue to do so. I definitely get that there are certain jobs where, that might be a possibility. However, especially at our work environment at Fox Smith, it's really kind of It's better for us to be in our office because, you know, we have such fantastic, you know, colleagues that I work with every day that we really, you know, do collaborate a lot. And so it's really nice. You know, if I have a particular issue, I know I can go down the hall to Ron or Ted or Bart or really anybody, you know, in our office and then, you know, get their thoughts on something. Because especially if I have a lawsuit that's been filed in, you know, the city of St. Louis with a particular judge or in Madison County, I can almost guarantee you that we have an attorney in our office who has dealt with that judge or dealt with an issue that I'm dealing with. And so it's really nice to kind of have a physical environment where I can go to and, you know, discuss various issues with my colleagues. However, for those of you who do have remote employers, obviously that presents a host of legal issues, you know, that I'm going to talk about a little bit more detail. So first, if you do have a remote policy, you need to determine who should be allowed to work remotely. So in order to do that, you need to analyze what work can be done remotely and what criteria should be applied. In addition, this criteria should be objective, based on legitimate business reasons, and applied consistently. Also, the request to work remotely due to a medical condition, you should treat that as a request for an accommodation. Also, you need to be mindful of out-of-state employees. Okay, there we go. You need to be mindful if you have employers who are out-of-state employees. So, for example, since we're, you know, located right across from Illinois in our office, we have some people who work in Missouri and some people who work in Illinois. So you just need to be mindful if you have other employees who work in other states, because there might be other states' legal requirements for conducting business there. Also, you need to protect your company data. So in the age of where we're not just in one office building and there's people spread out throughout, you know, their own home offices, you need to consider both your company and personal devices and the need for proper data and cybersecurity practices, which is critical. And we have Ryan Moore in our office who deals a lot with cybersecurity. So if you have specific issues with that, feel free to talk to him more about that in detail. Also, wage and hour issues. This includes cases disputing compensation practices, expanded schedules, and on-call time. And numerous lawsuits have been filed involving denial of sick leave or family medical leave for reasons related to COVID. In addition, with people working remotely from home, companies have kind of implemented more monitoring from work. So there's technology that provides employers with the ability to monitor productivity at home. But with that, there are issues relating to privacy laws about when telephone calls are recorded, Zoom meetings being recorded, team calls, and internet usage. And also there could be health-related issues pertaining to HIPAA as well that you need to be aware of. Additionally, you know, harassment policies still apply even if you're working remotely. Really, you know, one of the examples is kind of know your surroundings. So if you're having a meeting at home by Zoom, you know, just kind of be aware of, you know, what's in the background and just kind of, you know, make sure, you know, that everything that, you know, you're displaying on your monitor from at home complies with your work's harassment policies as well. And in addition, employers might be liable for injuries to an employee who suffers while working at home under state working compensation law. So you need to be aware of that as well. Okay, so again, kind of what does this mean for you? So employers should have a written remote policy in place and periodically review it and you know, update it as needed. So remote workers should acknowledge the policy and any updates by signing it, kind of as Maggie has suggested. You need to provide training on these policies, and they should include kind of a list of these following topics that I've kind of outlined for you. It includes procedure for requesting to work remotely, description of the required job duties and expected work product, any employee monitoring practices that you might be using, workspace and work equipment. Really kind of a recommendation if you do have people working from home is to have them kind of designate a specific workspace. So then if there are injuries or something that occurs, they have a designated workspace where, it kind of separates their work environment from their home environment. Also, it should address data security practices, timekeeping policies, prohibited conduct, on-the-job injuries, and reasonable accommodations and leave requests. With that, I'm going to hand it over to Stas.
All right, good morning. What I'm going to talk about is this upcoming OSHA directive that we will probably be getting, I don't know, sometime in the next 1 to 3 months. And I wish I could be more specific on that, but we just don't have the details, and I'll talk to you about why. Recently, the Biden administration put out what people call a vaccine mandate that's upcoming for all employers that employ more than 100 workers. There were a number of other directives that were put out at the same time. I want to get into that. And the word mandate is in quotes because there are, obviously it doesn't apply to everybody. It also offers other accommodations for people who insist on not being vaccinated. So it's not truly a mandatory thing. And as we'll talk about here, what the goal of this presentation is to kind of go over what limited information we do know so far, what we can learn from when similar issues have been litigated in the past, because as with any executive action on something that's fairly controversial still, you can anticipate there will be legal challenges, and really what it likely means for any employer that may be subject to the mandate if you do have 100 or more employees. So with that, let me get to my first slide here. Hopefully I don't hit one of these buttons that I think will break everything. So really this is directly from the White House's website, and there's 5 points to this, the first of which we talked about this before. All employers with 100 plus employees are to ensure that their workers are vaccinated or tested weekly. The second is a requirement that all federal workers and contractors that do business with the federal government all be vaccinated, and that is irregardless of the size of that company. If you do business with the federal government, you will have to have your employees vaccinated. That is something we'll talk about a little bit, how some of these requirements are going to be implemented through OSHA. That second one, I think, is just purely a function of an executive order. So it's going to have a lot less, there are a lot less requirements to that in terms of what the federal government has to show to mandate that. The third point that the White House put out was that they are going to expand the vaccine requirements for healthcare workers. This is something that was put out several months ago for certain healthcare workers, and now this is going to be expanded significantly. And what it's meant to do is it's meant to hit nursing homes and elder care facilities as well as hospitals. Get into that a little bit soon. And then there's points 4 and 5. 4 really is just kind of an aspirational goal. There's not really a policy or a regulation or law that can put in place to enforce this, but they want large entertainment venues to require proof of vaccination or testing for entry. Just being, in St. Louis and a sports fan myself, I know the Blues have implemented this starting when they open up the regular season. As far as I'm aware, the Cardinals have not, but I know that there are other venues, other sporting franchises that have implemented similar policies. That could be a function of the fact that, the NHL, plays games indoors, whereas, baseball stadiums, there's a lot of outdoor seating, mostly outdoor seating. So maybe that's something that the Cardinals are considering. I don't know, but I think that, the Blues are not a franchise that is typically at the forefront of some of this stuff. And so if they're implementing it, I think you can anticipate a lot of other cities implementing this in indoor sporting and entertainment venues. And the fifth one, which also impacts number 1, is that you have to, if you are under this, quote unquote mandate, you will need to provide paid time off for vaccination and potential side effects post-vaccination. And that, could be a couple of days of people feeling, having fever or feeling achy, things like that. Number 1 and number 5, again, are going to be implemented through OSHA, and we'll talk about exactly what that means. everybody see the top of that? All right, that's just my screen that's cutting that off. OSHA implementation on this is going to be done through an emergency temporary standard that's referred to as an ETS. Those standards are typically good for 6 months, and what that 6-month window is good for, it's meant to give OSHA time to promulgate a permanent rule, which is subject to the full notice and comment rulemaking, and that full notice and comment rulemaking can sometimes take years. I imagine it'll be expedited for something like this, but really this is something that is a relatively brief window in terms of when this will, how long this will take effect for. The courts have held that this is supposed to be only used in limited situations in which a grave danger exists. What is and is not a grave danger is typically something that courts will defer to OSHA on. And I'll talk to you about a case in which that came up and what the court said on that. And the second factor here is that when there's something like this that's implemented, the protection afforded to the workers has to outweigh the economic consequence to the regulated industry. And I'll give you some specifics on what that's meant in the past as well. Lastly, when courts evaluate this, it's got to be supported by what they refer to as substantial evidence. Now, taking all of this in mind, the reporting out there on what the White House put out and the interplay with OSHA is that OSHA was caught pretty off guard by the new standards here. And so, you know, I'm a little bit skeptical myself on reports that say that this is coming out any day now, any week now. The last ETS that came out, I think this past summer for the healthcare industry is something that OSHA has reportedly planned that for 2 to 3 months before putting that out as an ETS. It's hard for me to imagine a scenario where they take less time to bring out an ETS that is more expansive and affects, you know, more industries. And so I think, not knowing when it's going to come out, there's not been an announcement. I would anticipate that it would be closer to the end of the year than September's just about done. I don't see it coming out in October, although we just don't know. Just in terms of timing and what you can anticipate, this map is a pretty handy tool to see, you know, which states are covered by local OSHA boards and which states are covered by the federal OSHA standards. The rules say that if you're operating in one of these blue states, the state OSHA board will have an additional 30 days to come out with an emergency temporary standard that is at least as stringent as the federal OSHA temporary standard. Realistically, that distinction doesn't have a lot of meaning, but what it does is it allows these blue states really an extra 30 days to try to slow walk these requirements if they want to. So it's something that I could see some of these states doing if they want to, decrease the burden or give companies in their states a little bit more time to formulate a plan to comply with it. Very likely, the state OSHA requirement on this is going to mimic the federal OSHA requirement, but it's just something to keep in mind in terms of timing and how you can plan for implementing some policies at your office, depending on where your company operates. The OSHA emergency temporary standards have very limited success in the past when they're challenged in court. This is a list here of, and it also, what this slide should show you is how rare these emergency temporary standards are. There's very limited history on these, and in the past, they are typically very narrowly tailored to certain industries or specific products. So what they've passed, or what they're going to implement with this vaccine mandate is the most expansive and the broadest emergency temporary standard that they've ever done. And so what I think we should take a look at, first of all, this list could kind of tell you that, who knows what's going to happen with that, and who knows if it's going to survive in court. I think it's instructive to take a look at this 1983 asbestos challenge to see if we can get some guidance on what we can anticipate courts looking at when the inevitable legal challenges come to this emergency temporary standard. And before we go into that, the current standard that was implemented in June regarding the healthcare industry has been challenged legally, and those cases are pending. As far as I know, there are cases pending in the Ninth Circuit and in the DC Circuit courts of appeals on that, but they have not been decided. There's not a ruling that I can kind of reference at this point. All I can tell you that is it's kind of up in the air. Now, in terms of the last successful challenge, we'll talk about this 1984 decision out of the Fifth Circuit, Asbestos Information Association of North America versus OSHA. So first of all, what I'll say is the Fifth Circuit, I think even back in 1984, and I know today, is probably the most conservative of the circuit courts of appeal. If somebody is challenging one of these emergency temporary standards, the Fifth Circuit is where they want to be. As I understand it, the circuit assignments for these are meant to be random. So it's not, my understanding is that attorneys challenging this cannot strategically file in one circuit or another. So that's another question mark in terms of where it goes. For this specific case, this was a situation where OSHA wanted to reduce asbestos exposure to combat associated cancers and mesothelioma. You know, cancers and mesothelioma are obviously, you know, exposure to asbestos doesn't lead to immediate results like that. And anything that OSHA presented to the court was going to be speculative. So what they did was they had their data analysts try to extrapolate, calculate exactly what the impact would be of decreasing the asbestos exposure levels. And they decreased it by, I want to say they were trying to decrease the standard by about 50 to 75%, without getting into the math equations in this case specifically. But they said that essentially what we're looking at is if you allow us to implement the 6-month standard, we're going to save about 80 lives over the entire industry that deals with drywall and asbestos exposure and things like that. And OSHA argued that, you know, in excess of 80 lives lost is enough for a grave danger, to call it a grave danger. And they also said that compliance would not cost any company more than 7.2 cents for every dollar of sales, which does not seem like a small number, 7% of profits, but that is the standard that OSHA was arguing for in the Fifth Circuit in a pretty conservative place. Now, the result of this was ultimately the Fifth Circuit did not uphold the standard, but they gave OSHA a lot of deference. They said that 80 lives, you know, if you could save an additional 80 lives than you would otherwise, that's enough for a grave danger. That's fine. We'll give you that. They also said that the cost is not unreasonable if that's really what you're addressing, that grave danger. But using the substantial evidence standard, they found that OSHA's data doesn't actually meet this 80 life threshold that they say that it does. The opinion actually talks about, I mean, this is in the 80s, they talked about lawyers giving the court boxes and boxes and boxes of documents. I mean, these days it would be describing it as, you know, megabytes and gigabytes of documents. But they took a deep dive into it, and they said that, you know, when you actually look at the math and what industries are already doing and the standards in which they're working at, you're really looking at closer to 40 lives saved. And that's not quite the grave danger that 80 is. It's a little bit arbitrary, but that's what the court said. You know, and realistically, I think some of the wording in the opinion says, yeah, it's probably 40. It might even be as low as 20 or 15. So they basically said that all of this is really just not as much of a solution to as big a problem as you say it is. And that's ultimately why it was struck down. Now, knowing how heavily OSHA was scrutinized in this Fifth Circuit case is another reason why I think OSHA is very likely to take its time in promulgating this new emergency temporary standard and gathering its data so that it has everything at the ready for when they have to go defend this in court. So the question then is, why is the Biden administration so confident that the mandate will be upheld? And the answer to that, you have to go way, way back to a 1905 Supreme Court case of Jacobson versus the Commonwealth of Massachusetts. Now, this is a case in which this is during the time of the smallpox pandemic. And Massachusetts had a law straight up mandating vaccinations for any adult and all children, except for children that have essentially a medical reason why they shouldn't be getting a vaccine. The vaccine was free, and the penalty for refusing was $5. I looked at the inflation calculations, and that's about $160 for the ticket. That's the equivalent in today's dollars. Now, this man named Jacobson refused the vaccine for a lot of reasons, but essentially he challenged its constitutionality on a variety of grounds. He was, they tried him in state court. He was found guilty, and he was ordered to pay the fine, $160, or be committed to jail until the fine is paid, which seems a little bit extreme for a $160 fine, but that's what the state of Massachusetts, the Commonwealth, did. When the Supreme Court looked at this case, they essentially stated this mandate is constitutional. There should be an additional exception for adults that have a reasonable medical, need a medical accommodation for why they're unfit for vaccination. But other than that, this a mandatory vaccine to fight a pandemic, in that case, the smallpox pandemic, is within the state's police powers. Some of the key lines, we talked about the police powers here. One of the key things that the Supreme Court did there was on a question of whether or not the vaccine accomplished what it said it was going to be, on whether or not it was scientifically a good decision, or if it was effective, questions of side effects, things like that. They said that is not our role. We're deferring to the legislative body, the policymakers, the local health boards on that decision. And throughout Supreme Court case law, federal case law, there is a strong line of cases of the judicial branch deferring to to the legislative branch on those types of decisions. So a challenge to the vaccine mandate that tries to focus on whether or not the vaccine is effective, whether or not the vaccine is safe, things like that, that's unlikely to get a lot of play, especially in these higher level courts like Fifth Circuit or any other circuit. The key line, which I think I would open up a brief if I'm defending this, is Justice Harlan's quote that upon the principle of self-defense, of paramount necessity, a community has the right to protect itself against an epidemic of disease which threatens the safety of its members. That quote goes on, but I think that that's very strong language that says that the government does have a right, when the circumstances call for it, to implement mandatory vaccines. Now, just looking at these facts and a very powerful quote like that, you would think it's kind of an open and closed case. However, there is some what's called dicta for the non-lawyers listening to this. There are lines in the case that are not essential to the holding, but which can be cited as pretty meaningful for somebody litigating this. So they can, there's a line in here that talks about how this is typically a matter that does not concern the national government. Should be more of a local matter or maybe a state level matter. Now, reading that case, that line is really there in the context of why are we looking at a federal constitutional challenge to a local state law? It's meant to explain that, essentially, if the state is violating your, federally constitutional rights, we're still going to look at that. But as any attorney in the room knows, or as anybody that's dealt with these kind of situations knows, dicta is quoted and misquoted and applied in various ways to make a point. And depending on the judge that you're in front of, it can be pretty compelling if it's used correctly. So something else that you should keep in mind is there has been some sniping among the Supreme Court justices themselves recently in dissenting and concurring opinion on a pandemic case, the Roman Catholic Diocese of Brooklyn versus Cuomo. This is a case from New York where the New York state government tried to limit the size of gatherings because of the pandemic. There was a challenge, somebody filed on behalf of, I think, a synagogue and then a Catholic church saying that you're not allowed to do that. It ultimately came down as a 5-4 decision against the state, saying they couldn't do it. But within that decision, Justice Gorsuch has this concurring opinion that says you need to be careful because this Jacobson case shouldn't be taken as this big towering authority that overshadows the Constitution during a pandemic. I think just by reading that, you can kind of understand where he may go when this comes up for a challenge if it gets to the Supreme Court, if they grant cert. Justice Roberts, Chief Justice Roberts, for his part, kind of sniped back a little bit, and ultimately this was not in a central hold or anything like that, but it gives you some hint of what's going to happen here. So this is a 1905 case. So how is this case, what's the progeny of this case? How has this case been applied to similar situations going forward? There is a long line of cases, and I've just given you a sampling of these citations that deal with vaccination requirements in schools. Uniformly, they are allowed in schools, and not just in elementary or high school education. The most recent case actually deals with the COVID vaccine from Indiana University. And it got all the way up to the Seventh Circuit Court of Appeals, and the Seventh Circuit Court of Appeals, kind of slapped down the challenge in a very brief opinion. I would say it's almost condescending the way that they treated the people that were complaining about this. And they essentially said, look, the university has a good interest in vaccinating, make sure all its kids are vaccinated. The people who are vaccinated want to avoid getting sick, have an interest in attending school in a place where they can have some assurance. Nobody wants to go back to online learning. And, you have other options. You can go to a different school. That kind of sums up that opinion. The quote there, it's a big block quote. I don't want to read the whole thing, but it's there for you if you want to look at the materials. In terms of non-school cases, I kind of try to look at these. There aren't very many of them, but we do have some situations where, first of all, mandatory testing for disease was upheld by the 10th Circuit in 1989. This is a unique situation. This was a case in which this was at the beginning of the AIDS epidemic back in the 80s. And the state wanted to implement mandatory blood testing for people in prisons. Prisoners challenged this based on their constitutional rights. And this, this is a blood test, which is much more invasive than any, kind of COVID test that you might be forced to implement if the employee does not want to get a vaccine. But the state held that the prison has a strong interest in responding to the threat of a contagious disease. At this time, very little was known about AIDS, or its transmission. And there are parts of the case where the court even says, well, the scientists are telling us that you can't catch it from somebody just by being in the same cell, but we're going to be really careful here and just, better safe than sorry and allow it. And they said that they want to weigh the magnitude of the intrusion against the extent to which the procedure may threaten, or which the pandemic may threaten the safety of the health of the individuals in the prison. And again, something like getting someone's blood, drawing their blood, which is a pretty intrusive thing, they decided that ultimately it was fine and it was within the state's police power. Another case that, it's a little bit, looking back at it, it's a little bit silly, at least it sounds that way. It's kind of hard to believe that this was the case reading about it, but the 10th Circuit again upheld not only testing, but mandatory medication to fight a venereal disease epidemic, which apparently was going on in Colorado in the 70s. And they actually cite to other states that had similar issues. This was a highly intrusive and invasive law that was on the books. It allowed police to essentially, if they have reasonable suspicion, which anybody that's worked in the criminal field knows is something that the police, you can characterize that as a lot of different things. If they think that someone is engaged in prostitution, they can arrest that person or order them to go to a clinic, order them to get tested for, I think at that point it was gonorrhea or syphilis, that was the big epidemic. And if they're found positive, they can order them to take penicillin. Or in the alternative, they could just come in and get a shot of penicillin and then they can be released. Alternatively, they could be held for 48 hours in a jail cell. This was challenged and ultimately it was upheld. And even as intrusive and invasive as this is, as burdensome as that is, the 10th Circuit, citing Jacobson, citing that old Supreme Court case, said, this falls under the police power of the state. There's an active epidemic we're trying to address. And this is a valid exercise by the government. So, you know, at the end of this, what exactly does this mean for dealing with the future OSHA ETS? Well, first of all, if you're relying on the court system to quickly, you know, implement a restraining order on this so it doesn't go into effect, I would advise against that. Because for a restraining order, you know, it's going to get challenged legally. People may even apply for a temporary restraining order to put the brakes on it. But the burden on a restraining order, first of all, you have to prove that you're likely to succeed in the litigation, and you have to prove that that you're going through irreparable harm in implementing this policy. In terms of that first question, I think that the law, the cases that have dealt with these issues in the past, at best, it's mixed. You know, in terms of if you're trying to challenge this. So relying on a TRO here is probably not the best way to go. If this does get overturned, it will likely be after months and months of litigation and ultimately a decision that's probably at the tail end of the 6-month period, which will mandate an employer to implement this while the case is pending. So the best thing that I can advise is what we advise at the end of a lot of these talks is to be proactive, to get some sense of, you know, if you are an employer that is going to be subject to this, get some sense of how many of your employees are vaccinated, how many are not, get some sense for, you know, how much it will cost and how you can facilitate testing for employees that insist on avoiding vaccination still, which is going to be their right under this mandate. And, you know, do what you can to encourage your employees to get vaccinated, try to get ahead of this so that when this does get implemented, it'll be minimally disruptive to your business, if it's disruptive at all. And the more you can do to plan for that, as if it's going to go into effect, which I think it will, the better off you're going to be once it does hit, once that order does get